we're going to get started with today's fabulous CLE program on social media and journalism and the courts and all of these things where they meet and implode. All right, so first off, I'm going to get us going with some messages from our sponsors. These are the folks that put the bill for all these courses, making them free for all of you. So I hope you will listen and be respectful and use their services should you find yourself in need.
I'm Bob Worden, mediator and arbitrator with NAM. I must say that in these times where everybody has to put up with social distancing, it's really difficult. But the one good thing is that virtual mediation or virtual arbitration works very well. So give it a try. And I think you can get your cases resolved just as easily as if you were there in person. And I look forward to mediating with you if you haven't tried me yet. I promise you it'll be a pleasant experience.
Awesome. Thanks so much, Bob, and our friends at NAM. We are going to take another sponsors break about halfway through today's course. So I'll give you a chance to jump up, run to the bathroom, scream at your kids, whatever you need to do. I'm going to turn it over to Amy Insler, who is our lawyer in residence for this CLE program. She is also one of the Academy's deans who helps us put together all of our CLE programming. And Amy is almost solely responsible for quite a number of CLE titles. She is my favorite person to make draft witty CLE titles. So thank you to Amy, especially for that. She is with the law firm of Bonina & Bonina, where she practices mostly serious injury and medical malpractice cases and has been doing so for 20 years. So all of that said, take it away, Amy.
Thanks, Michelle. Hello, everyone. Thank you for joining Bruce and I again, and this time with Tom for today's program. Bruce is CEO of Hennes Communications, which is one of the few firms in North America that focuses exclusively on crisis communication and crisis management. He is an adjunct professor at Cleveland State University and a member of the executive committee of the Cleveland Metropolitan Bar Association. Take it away, Bruce.
All right. Well, for those of you who heard me speak on the subject of crisis management and crisis communications for attorneys and their clients this past October 15 for the Academy of Trial Lawyers, welcome back. And please buckle up your seatbelts because you are about to hear a fascinating presentation on the subject of social media. And our guest speaker this afternoon is the managing partner of my firm, Thom Fladung. Tom has more than 33 years of daily newspaper and digital media experience under his belt, having served as top editor at some of the nation's largest newspapers that include the Cleveland Plain Dealer and the Detroit Free Press. Over the past decade, Fladung has played a lead role in helping newsrooms enter the digital age, including web, social media, and handheld digital devices. Tom is expert at crafting effective and strategic messages on hard deadlines. He's also experienced at quickly evaluating, assembling, and disseminating information, crisis management skills that are critically important for clients coping with reputation management issues and breaking crises. He's intimately familiar with the relentless content requirements of the 24/7 news cycle, and he understands the necessity and nuances of communicating on social media platforms such as Facebook and Twitter. He knows the crucial role social media plays as a first alert for many consumers of information and as a place where reputations can be bolstered or blistered. In his career, he's overseen newsrooms of more than 300 journalists, and he's directed dozens of award-winning investigations, breaking news stories, human interest stories, and features. You know, I often tell clients what I think media is thinking and what they might do with a given situation. And often I'm right, but Tom was the media. So this afternoon, sit back, set the client file aside, click close on the little X's on the upper right corners of your email and browser programs, if you will. And let's listen as Tom does his best to teach you a new skill set that you can deploy for the benefit of your clients. So with that, how about a warm Empire State welcome for Thom Fladung.
Thank you, Bruce. I appreciate it. And thank all of you for taking this time on a Monday afternoon. Let me just get this PowerPoint ready.
Perfect. You look great.
All right, let's go. So the media have long been fascinated with courts and trials, particularly criminal trials. it's understandable. There's built-in drama. There are frequently colorful characters. There's a story arc, which journalists work hard to create, and particularly with trials, is inherent. There's usually a good guy, a bad guy, and an outcome. And we have known for decades that there's intense reader and viewer interest in most trials. I mean, indeed, we've had more trials of the century than we've had centuries. And the courts, again, particularly trial court, have long been fodder for great media coverage. Now, for just as long, we've had tension between the Sixth Amendment right of a criminal defendant to receive a fair trial, and of course, the First Amendment right of the press to publish news about trials. Let's walk through some of the famous trials as they played out in the media. I think you're going to see many similarities in the coverage for decades, and then suddenly, and much more recently, a change. The Lindbergh baby, or Bruno Hauptmann trial, was one of the first in what we'll call the modern media era. It was 1935, and this trial absolutely riveted the nation. There was a long ramp up to the trial. Charles and Ann Lindbergh's baby was kidnapped from the family home on March 1st, 1932. 2 months later, baby's body was found a few miles from the home. After a 2-year investigation, Bruno Richard Hauptmann was arrested. The trial began in January 1935. This was truly an era when newspapers ruled as a primary source of news, and there were a lot of them. There were 15 newspapers in New York City alone at this time. There were 500 to 700 reporters at the trial, including 120 cameramen. And in case you think checkbook journalism or paying for stories is new, the Hearst newspaper chain paid the legal fees of Hauptmann's attorney in exchange for the exclusive right to interview Hauptmann's wife during the trial. Up to that point, I would argue, this was the most sensational trial, again, in what we'll define for the purposes of this as the modern media era. A couple of decades later, though, came Cleveland, Ohio's turn at bat. In the early morning hours of July 4th, 1954, Marilyn Shepard was bludgeoned to death. Husband Sam, a prominent doctor in Bay Village, which still is a Tony suburb of Cleveland, maintained that Marilyn was murdered by a bushy-haired intruder. Sam was charged and put on trial for murder. Massive press coverage ensued. The Cleveland press embarked on a mission demanding a quick action in the Shepard case. That included a front-page editorial with the headline, "Why no inquest? Do it now, Dr. Gerber." Later that same day, Coroner Sam Gerber indeed announced a call for an inquest to begin the next day. During jury selection, every prospective juror except one testified to reading or hearing about the case in the news media. The trial drew journalists from around the nation, including the most famous of that time, like Walter Winchell and Dorothy Kilgallen, who also happened to be a regular on the hugely popular TV quiz show, What's My Line? And that little fact, that little piece of trivia is just in case you thought celebrity journalists like Nancy Grace were a modern phenomenon. You see, there really is nothing new. The press was given virtually free rein in the Shepard courtroom, including reading and photographing documents on the prosecution and defense attorney tables. The judge did not order sequestering of the jury. Jurors' names and photos appeared in newspapers more than 40 times, including the example you see identifying each juror, which ran on the front page of the Cleveland Press. Jurors then received anonymous letters to their home addresses and direct requests for statements from the press during the trial. The jury deliberated for 4 days and was sequestered during that time, during deliberations for the first time. But the jurors were permitted to make unsupervised calls to their homes at that same time. The Shepard story was a national story. One of my old papers here, the Detroit Free Press, gave it big coverage. The jury verdicts: murder in the second degree. Now, was immediately appealed, eventually reached the U.S. Supreme Court, and the Supremes concluded Shepard did not receive a fair trial, calling it a carnival atmosphere and ordering the murder verdict invalid. Shepard, by the way, was acquitted at a second trial, went on to be a pro wrestler, known as the Strangler of all things, and he died of liver cancer shortly after. As you also may know, the Sam Shepard trial became the inspiration for The Fugitive TV show and later movies. So by Shepard, radio was well entrenched as a provider of breaking news, and TV was just getting a toehold. But really, newspapers still were the way we marked really big news events. The O.J. Simpson trial in 1995 also can be used as a marker for some big changes in media. By O.J., we were well into 24-hour cable news channels, and the internet was just beginning to be a source for news. This is from a New York Times story dated February 14th, 1995, and I quote, "Hard to believe, but there are some people who cannot get enough information about the O.J. Simpson murder trial from newspapers, magazines, television, books, and radio. The internet and other computer-based online information services are emerging as global repositories of trial news and trivia." That Times article labeled Simpson the first trial of the century and went on to report, "The OJ mania in cyberspace has also been fueled by internet's World Wide Web, which allows advanced internet users to navigate easily through text files, photographs, sound files, and even video clips. One area on the web, as it is called, allows visitors to view over and over a video clip of Mr. Simpson pleading not guilty at his arraignment. On America Online, remember AOL? There were 1.5 million subscribers on an OJ forum in the court and the OJ forum in the court TV section was a buzz with armchair analysts. Now, I will bet that right now, 1.5 million people are watching cat videos on their phones. Nevertheless, for the internet, this was a revolution. And for information sharing, this was a revolution. So yeah, some of it seems quaint now, but that Times reporter also was prescient. He wrote, "Unfortunately for Mr. Simpson, these virtual jurors and judges appear to have already reached their verdicts, posted as collections of online comments with subject lines like guilty as sin, which is next to one called guilty but will walk on a technicality. Far fewer are the subject lines that suggest Mr. Simpson is not guilty, like planting the glove and another setup theory." So with the Simpson trial, we're also watching the dawn of a media revolution. Still yet though, newspapers and newspaper reporting were following pretty much the style and substance the way they had been operating for decades, going back to the Hoffman trial. These newspapers, while looking more modern in design, really don't look dramatically different from the Hoffman era. And even with this dawn of the internet, people mostly learn about the Simpson verdict on TV and then read about it the next day in their newspaper. Finally, here's how the whole world found out about the verdict in the Casey Anthony trial in 2011. I exaggerate a little. Kim Kardashian didn't really break this story, but at that time she had 30 million followers on Twitter and 27 million on Instagram. The Casey Anthony trial in 2011 provides another marker in the story of how media covers trials. Time magazine called it the social media trial of the century. Reputable mainstream newspapers like the Orlando Sentinel went all in, covering the trial via something called Twitter, which had started about 4 years before, and lots of others followed. At the time Anthony's not guilty verdict was read, CNN Live's website had 30 times more viewers than its daily average the previous month. Coverage on Twitter, the use of Facebook, Snapchat, Instagram, and other social media sites now is an expectation for newspaper reporters when covering news events like a trial. And remember, all this has developed largely over the past 5 to 9 years. I would argue that that is a more dramatic change in journalism and how people get news about trials than anything that happened in the 76 years between the Bruno Hauptmann trial and Casey Anthony. And you're all right in the middle of it, living it. Now, as social media has grown, the line between social media and conventional media has blurred to the point now that they're often indistinguishable. Where do people go when news breaks? They go to social media because that's where the news is breaking. A May 2016 Pew Institute study reported that 62% of US adults get news on social media. 62%. And for context's sake, remember that went from 0 to 62 in about 7 years. By December 2018, Pew reported that for the first time, social media sites surpassed print newspapers as a news source for Americans, with about 20% of US adults saying they often get news via social media versus 16% from print newspapers. In breaking news situations, Twitter is the go-to news outlet. Here's one of the stories that first made that absolutely clear. On June 12th, 2016, around 2 a.m., a man walked into the Pulse nightclub in Orlando, Florida, and began shooting. At 2:09 a.m., the club posted on its Facebook page, "Everyone get out of Pulse and keep running." 8 minutes later, at 2:17 a.m., the world began to learn about the shooting from tweets like this one, which, as the tweet indicates, was sent by someone who was hiding in a restroom while the shooting was going on. After a 3-hour standoff, Orlando police shot and killed the gunman. And then they went straight to Twitter. Now think about that for a moment. This may not be surprising in the least today in 2020, but think about that for a moment in the context of when it happened. The Orlando police communicated the biggest news in the department's history first on Twitter. The Pulse nightclub shooting at the time was the deadliest mass shooting by a single shooter in US history. It also was a seminal event in showing how social media, and Twitter specifically, at least for now, is the place where news first happened. This is what you must remember. Social media isn't a technology. It's an enduring cultural shift. So coverage of big trials on Twitter now is an expectation for reporters. Why? First, immediacy. Twitter and the related social media gave print reporters a tool they had never had. Waiting for the presses to run and the papers to come off the line and to be distributed, while romantic, was terrible for newspaper reporters who needed to compete in the moment. Twitter solved that problem for them. It also helped establish reporters as authorities on the subject as they tweeted day after day about it. It gave us the ability, it's not an us anymore, my apologies. It gave reporters the ability to reach readers who otherwise would never come to the story or never be reachable by that media outlet from literally around the world. And it provided an alternative for courts, such as federal court, where cameras still are largely not allowed. That was all highlighted in 2013 by the trial of mobster Whitey Bulger in Boston. Journalist Jim Armstrong covered that Bulger trial for the Boston Globe. And he wrote, "In federal court, where cameras are not allowed, Twitter became a tremendously valuable way for me to explain what was happening. Had the trial been televised, viewers could have seen for themselves what was going on minute by minute. So to compensate for the lack of TV coverage in the court, I tweeted minute by minute, or at least it felt like it was that frequent on some days, to describe the courtroom and everything going on. And Judge Mark Bennett of the United States District Court for the Northern District of Iowa, in an interview with the ABA Journal a few years ago, offered this perspective on the changing media coverage of trials. I thought the public's right to know what goes on in federal court and the transparency that would be given the proceedings by live blogging outweighed any potential prejudice to the defendant. I allowed it because of my belief that we are the most mysterious branch of federal government, and we need to find ways to be more transparent. Twitter also is one of the key tools in a process called iterative reporting. I'm not going to ask for a show of hands because I can't see any of you as to who's actually heard of iterative reporting. But in my experience, very few people outside of newsrooms know about it, understand it, or are talking about it. It's the most fundamental change I believe I saw in the journalism business in the 33 years that I did it. And if you're involved in a trial deemed to be newsworthy, or you or your firm get caught up in a breaking news story, or a crisis, or a big problem, you're going to be part of iterative reporting. You're going to be subject to it. In a nutshell, iterative reporting is exactly what it says. Stories are built iteratively, piece by piece. At some news outlets, a story just keeps getting updated with new information added throughout the day. At others, each of those pieces is a standalone story online that another person then compiles into the larger story that'll go eventually onto the website or in print if the outlet still has a print edition. So reporters are literally building the story before your eyes. The greater whole spools out in these little bites. But what it also means is a reporter, once he or she is convinced that the basic facts are known and that this is a worthy news story, will post the story to the web with a tweet with a link to that story, short note, and link on that newspaper or TV station's Facebook page, etc. So for news sources like you, here's why that's significant. All the reporters I know still will try to call you to get a comment, get your side of the story. But I emphasize in this case the word try, because here's the key difference. In my years of newspapering, I was screamed at by editors, and I screamed at reporters, "You don't have the story." And that meant a story wasn't ready until we had done our damnedest to get all sides. Depending on the story, that might mean more than a half dozen phone calls trying to reach you. And, if it was bad news about you or your organization, we understood that you tried to dodge that. You tried to dodge us. You didn't want to be reported on. So we called. We camped out in your office. We left business cards at your house. At one of my newspapers, the Detroit Free Press, we used to use certified mail to request a response. And we held stories to get that information, to get those interviews, including when we knew we might get beat by a competitor. A few years ago, some of you or most of you may have seen Spotlight. It's the Academy Award-winning movie that tells the story of the Boston Globe's investigation of abuse in the Catholic Church. One of my favorite scenes in that movie, the Boston Globe editor, Marty Barron, who now is the editor of the Washington Post, is talking to the team of reporters who have tied one incident of abuse to an archbishop, and they're ready to publish because they've got the story in their opinion. They've tied it. They can demonstrate that someone in that position of authority knew about that instance. Much to their concern, as they're worried about getting beat on the story, Barry tells them no, they don't have it. And he says, we need to focus on the situation, not the individual priests. This is the dialogue from the movie. Practice and policy. Show me the church manipulated the system so that these guys wouldn't have to face charges. Show me they put those same priests back into parishes time and time again. So Spotlight highlighted waiting to have the whole story. You don't have the story until you can till you try to contact people and you can trace it back to them. And at the Detroit Free Press, again, one of my newspapers, we used to require, particularly on sensitive stories, that reporters showed us 6 independent ways they tried to contact the key sources for a story before we allowed them to put in the story could not be reached for comment. But compare that with Spotlight, with the Boston Globe's more recent award-winning expose of abuse in New England boarding schools. That was 2 years ago. In that case, the Globe still did plenty of reporting, documenting several stories of abuse, but when they had a story ready, they published. And then they asked readers to contact them with other instances, other examples of abuse, other reports of abuse, and reader responses flooded in. That's building a story iteratively, even in this case, a deeply reported investigative story. So stories now are much less likely to be held until you respond. Here's why. Readership online is largely driven by search, people searching for specific stories or story topics. The majority of, for instance, the majority of a news outlet's website traffic will come from 2 places, Google and Facebook. And if my story is online sooner than your story, even by a minute, it can mean thousands of more readers for my story. Because Google often will list the story that first broke a subject at the top of the page when people search for it. And that's gold to get readers. We know from research that we've done in various newsrooms that the top 3, you need to be in the top 3 results. So if someone Googles New York State Academy of Trial Lawyers because there's some scandal going on, not that that would ever happen, and my story is not in the first 3 results, I'm getting a lot less readers. If it's not on the first page, I'm dead. I might as well not have written it because nobody searches to the second page. So now that's why it's an accepted practice, and beyond accepted, it's expected to publish a story before you've spoken to all the key people involved. You still got to get the basic facts right. You still got to play fair and try to contact everyone once, but they're not waiting. And then when you do catch up with them, either update the original story or do a new story. So maybe they'll get back to you and maybe they won't. Maybe your side of the matter will be part of that first crucial story. Maybe it won't. Here's why that's important to you if you're caught up in that. If you wait to call the reporter back, if you can't react quickly with what you want to say, your voice and your position won't be in the original story. And it's almost always the original story that gets many, many more readers. And you want your voice and your side of the story to be seen by those readers. It's also important to understand what to do if a first version of that story is published online, your side of the matter isn't reflected in it. If at all possible, try to get that reporter to do another separate story reflecting your side. And this is as opposed to the reporter going in and updating that original story. Why? Well, about 60% of traffic to news websites now is coming on smartphones. Now ask yourselves, you ever read news on your smartphone? Do you ever go back to look up that story you read an hour ago to see if it got updated? Maybe you do. I've had a few people in these forums tell me they do, and God bless them for being that kind of news consumer. But the vast majority of people don't. You don't go back to see if the story was updated. It's a river of news flowing through your phone, and you're looking at the next new one. So getting a news story with your side of the story gives you a new headline. And depending on Google Analytics, a chance to get your story near the original in search, if not above it. How does this play out in a trial setting? The story will be built piece by piece as the trial goes on. And if the trial is being tweeted, it's going to be covered in those short bursts. Now, high-profile trials have been given daily coverage, as we discussed, for decades. The reporter would spend the day in court if possible, and if permitted by the court, try to talk to some of the people about that day's trial, and then do a story for the next morning. Now it's all real time, and it's interactive. That, to me, is the crucial new factor, which means a reporter is tweeting or posting iterative stories about your opening arguments, your cross-examination of a crucial witness, and the story is going online within minutes of that testimony. And readers are then weighing in on Twitter or in the comments section attached to stories. Does that affect a witness who might have additional testimony to give? Does it affect how you might do closing arguments? We're going to discuss all that and more and take a deep dive into social media and how it plays out in trials and how attorneys from across the nation are using it. In just a sec, we're going to take a break. I'm also aware there's some questions coming in, and we'll address those before we resume. But let's pause.
So before we get back to Tom, I also want to share some messages from our sponsors again, that these are the folks putting the bill, and we appreciate that. So please listen to their messages and use their services. Here we go.
Hello, Academy members. My name is Vogie Best, and I oversee business development for Robson Forensic in the New York City area. Now, in case you don't know us, we are a multidisciplinary forensic firm with a very broad range of experts. You can go to robsonforensic.com to view their CVs. You can also check out our weekly webinar series, which continues. You can find me at the website by searching my name, Vogie, B-O-G-E-Y, like golf, Best, B-E-S-T, or you can email me at bbest@robsonforensic.com, and I will be more than happy to get an expert in touch. Thank you very much.
Hey, Academy members, Ross Maller from PM Legal here. We are New York's #1 most experienced process serving and private investigations firm, available to you 24/7. We served almost 200,000 documents in 2019. We handle new case signups, scene investigations, witness statements, obtaining police reports, medical records, and much more. Email me at help@pmlegal.com to discuss our services further and see why the readers of the New York Law Journal have voted us #1 in New York. Thank you very much.
Thank you so much, Ross and Vogie and all of our sponsors. All right, I'm going to end that attendance verification poll. There'll be at least one more of those as we get closer to the end. There's a bunch of questions in the Q&A. I would like us to keep them for the end, but Tom, you do you. If you want to hit any now, feel free. And if anybody has logistical issues, just email us, info@trialacademy.org. All right, back to you, Tom.
Thank you. Try to resume sharing this screen.
Go for it. Perfect.
How's that look?
Looks great.
All right, let's just check out a few of the Q&As just to see where we are here. See if there are any that we should answer immediately. And Michelle, if you think there are any that I should answer immediately, please yell out.
Oh, sure. Are you looking at them or you want me to throw them at you?
Why don't you throw them at me?
Okay, yeah, sorry, no worries. Bernadette asks, and by the way, Bernadette has one of our upcoming CLEs happening on January 7th, the trauma of terror, which is all about, pain and suffering and pre-impact terror damages. Should be fascinating. But anyway, her question is, what about the responsibility of the media to curtail reporting of misinformation, like Trump's misinformation about COVID-19 and the election? Doesn't that amplify the misinformation, AKA the lies?
It does, and this has been a real struggle for the media. We've watched this struggle play out in real time as well. We've not, in my years of doing it, I never experienced anything like this. One of the ethics from my era of journalism was, clearly, if you reported about the misinformation, shed light on it, because light would solve all. So you shed light on it, and then the lie is exposed, the misinformation is exposed, and people go about their business. That's changed. That's clearly changed. I do a whole CLE, by the way, about fake news too, which I would be happy to do sometime for y'all. But to shorten this, the media has tried to do that with reporting that I'd never seen before, calling things lies, which you can go back and view the previous 40 years of journalism and not find an example. You'll now find numerous examples. For a variety of reasons, it's been a real struggle. And so as this applies, though, particularly to trials and the reporting of information, one of the dangers here is when you're live tweeting a trial, you may well tweet information, witness testimony, that a judge later rules should not be used. And guess what? It's out on Twitter, it's public, and it's going to live forever. and it's not something that's been very heavily researched. We're going to talk about that and other examples. Michelle, other questions?
Tom, Michelle's having me do them for you. So
Thanks, Amy.
no problem. Question came in. I'm wondering, what are your thoughts on how drama channels can report on sensational breaking news without overstepping the boundaries of law enforcement and the courts and possibly getting sued themselves?
Yeah. Not a big fan of drama channels. It might surprise you to hear, but they are a reality and they get an enormous amount of viewership. Ultimately, a lot of these things that we're going to talk about are redolent of the yellow journalism era of the late 1890s and early 1900s. And we know what solved that. Readers turned away from it. It got so sensational and there was so much misinformation starting to circulate that readers started to reject it. Readers ultimately control this process. They really do. And they vote with their wallets and they vote with their clicks when they're clicking on the internet. So if those drama channels continue to get that kind of attention, they're going to continue to report. The other thing that readers can do, though, is hold their feet to the fire. You have direct access to journalists, unlike any time in history. And the other thing you can do is, if you believe you have seen misinformation, you believe you've seen fake news, please don't exacerbate it by retweeting it, by sharing it on Facebook. It's up to all of us, really, as news consumers, to try to stop this and dampen it.
Another question is, how are journalists using Twitter trained to deal with objections?
They're really not trained to deal with objections. Now, that said, if you have a veteran court reporter, and unfortunately for a variety of reasons, there are fewer of them because of the financial hardships the industry has experienced. Still, though, many very veteran court reporters at some of the larger newspapers. It's at many of the medium metropolitan papers and then smaller papers where you have less experienced people now reporting on the courts. They're not really trained to deal with objections. I will tell you from my experience in newsrooms that when we were live tweeting trials, we didn't sit down together and say, okay, how are we going to deal with objections? How are we going to deal with a judge ruling some information is not admissible? It was pretty much the wild, wild west. That's an interesting question, though, and I haven't done that. I haven't researched that in the several years since I left the business. I'm going to do that with some colleagues. I love that.
Okay. And the last one we'll do for now is, what role do you think artificial intelligence will play in upcoming media changes?
Well, it allows, on a small level, it allows media outlets to exist without human writers and editors. And right now, this is not covering any serious news, but it's artificial intelligence can produce stories based on those facts. And it's obviously a really cheap way to produce stories, try to attract online advertising and get clicks. That will expand if readers use it, if readers embrace it and they click on it. Okay, let's get back to this. So we've been talking a lot about Twitter thus far. I just want to very briefly talk about Facebook, because it is the largest social network. And as we mentioned earlier, Pew Research Center reported in December 2018 that social media sites had surpassed print newspapers as a news source for Americans. That is largely Facebook driven. Facebook is how we tell people about things. And we've always, by the way, we have always known in newspapers, we've known for a long time that one of the main drivers of readership is if someone tells someone else, hey, you ought to go check out that story about X or Y, you are much more likely to go read it. Well, Facebook takes that water cooler conversation, that over the fence conversation, to use the cliches, and it puts it on steroids. And it allows you to tell 1,000 of your friends, hey, you ought to check out this story. That's made Facebook very powerful for people that write news and try to attract readership. That said, people were talking about artificial intelligence, bots, fake news. Pew has since reported since 2018 that even as they regularly turn to social media for news, a majority of Americans, 57%, who often get news on social media, say they expect the news they see in these platforms to be largely inaccurate. Concerns about the inaccuracies in news on social media are prevalent, even among those who say they prefer to get their news there. I have no explanation for this. Well, I will tell you that when I was still a newspaper editor and saw research like this, I wanted to go play in traffic. So Facebook continues to dominate as the most common social media site used for news by Americans. What does all this mean? It means social media has been and is having a profound impact on what you do as trial lawyers. There's been a fair amount of attention paid to the impact of social media on jurors and the jury process, probably because of trial results like this. In Michigan in 2010, a juror in a case of resisting arrest writes on Facebook that it's going to be fun to tell the defendant they're guilty, helpfully putting guilty in all caps. The trial wasn't over. Their juror was removed and later fined $250 and ordered to write an essay about the constitutional right to a fair trial. In Arkansas, a death row inmate faced a murder trial. Before opening arguments, the judge told the jury, just remember, never discuss this case over your cell phone and don't Twitter anybody about this case. One juror commenced to Twitter throughout the trial, including tweeting less than an hour before the jury announced its verdict, "It's over." The Arkansas State Supreme Court threw out the murder conviction. Kentucky, 2012, the murder conviction of a man who drove drunk and crashed his truck into a vehicle, killing an 11-year-old, was reversed and remanded by the Kentucky Supreme Court after an appeal that noted two of the jurors were Facebook friends with the 11-year-old's mother. And that mother had posted info about her daughter's death on her Facebook page. During general voir dire, the two jurors did not respond when all were asked if any knew the victim or her family. During individual voir dire, one juror said she had a Facebook account from which she knew only that the murder happened. The other said she was not on Facebook. Interestingly, the Supreme Court disagreed with the appeals argument that being a Facebook friend with someone creates a presumption of juror bias. The court said Facebook friendships do not necessarily carry the same weight as true friendships or relationships in the community, which are generally the concern during voir dire. But the court reversed because of the jurors' apparent misstatements during voir dire and the trial court's inadequate investigation of the relationship between the jurors and the victim's mother. Then there are the many examples of jurors now using social media to help them decide a verdict. A few highlights. In a first-degree murder and child abuse case in Colorado, in which a woman was accused of killing her 4-month-old grandson, a juror researched the prescription drug Paxil, which was being taken by the defendant, and shared that research with other jurors during deliberation. The court had denied the jury's request for a physician's desk reference about the drug. The Colorado Supreme Court affirmed an appeals court reversal of a conviction for child abuse, resulting in death in that case. In Maryland, in 2009, a man was tried on various charges of sexual abuse, including 2 counts of incest with his 17-year-old daughter. He was convicted of 3 counts of assault, but the jury deadlocked on the incest charges. During testimony, the daughter's therapeutic behavioral specialist said the daughter was diagnosed with ODD, oppositional defiant disorder, without providing any explanation as to what ODD is. So, a juror told his fellow jurors that according to his internet research, lying was a characteristic of ODD. The trial court judge learned via a note from the jury what the juror did, but refused to declare a mistrial. An appeals court, however, ruled that the jury should have been polled to determine whether it could still render an impartial verdict based on the trial evidence and required a new trial. In New Jersey in 2009, an appeals court reversed the convictions of 3 cousins for aggravated manslaughter after a juror told her fellow jurors that she'd researched the defendants, the victims, and the possible sentence for conviction on the internet and announced at the start of deliberations that she'd already decided. fellow juror, came forward with this information, and the trial judge replaced the researching juror with an alternate, but held that the remaining jurors were not tainted. So courts, of course, have reacted to all this. Just this year, 2020, a federal judiciary committee issued a new set of model jury instructions, updating and expanding on a similar version that had been issued in 2012, which comparatively was the Jurassic era of social media. Among the changes is the suggestion that reminders about social media restrictions be given throughout the trial, not just at beginning and end. And it certainly seemed that changes needed to be made. The jurors listening to instructions to stay off the internet and social media whenever and however often they're given. The example I'm citing here is obviously getting dated, and there doesn't seem to be more recent solid research on this. But as the Wall Street Journal reported in 2012, according to a survey by the Federal Judicial Center, nearly 8 out of 10 judges said they had no way of knowing whether jurors were observing a social media ban during trials, which of course has led to trials like the Google mistrial of 2009. That was an 8-week trial that ended when a juror reported that a fellow juror told the panel he'd done internet research and found evidence specifically excluded from the trial. Upon questioning by the judge, 8 other jurors said they'd also done internet research contrary to the judge's instruction. Much more recently, consider the federal trial of Mexican drug lord Joaquin Guzman, El Chapo. The court took painstaking efforts to advise jurors to stay away from any reporting, commentary, or discussion about the case. But it was a media and social media blitz on the case and the trial, and avoiding outside coverage was next to impossible. According to a note written by a sitting juror following El Chapo's conviction, at least 5 jurors ignored the judge's instructions and lied to the court when asked during trial whether they had avoided all media coverage. You know how we were told we can't look at the media during the trial? A juror told Vice News. Well, we did. Judges in some jurisdictions, including California, and as I'm sure many of you are familiar, retired U.S. District Court Judge Shira Shenlin of the Southern District of New York, have tried requiring jurors to sign pledges before the start of trial, promising under penalty of perjury that they will not conduct outside research or watch or read any media coverage. Now, various studies have shown the power and influence of honesty pledges on the front end. Some examples. When a group of students was asked to recall the 10 commandments prior to reporting their answers, there was no cheating. Another group of students were asked to sign their school honor code before taking a test. There was no cheating, even though their school didn't have an honor code. And then there was the Princeton student test. Princeton's formal and stringent honor code is drilled into freshmen at orientation. Each student must also sign the honor code on every test and paper. When the students were tested 2 weeks after orientation, they cheated, except when they were reminded of the code right before the experiment. So what does all this tell us? Jury admonitions may not work if clustered with other numerous admonitions and lost by the jury glaze over at the end of each day. But an oath, hand up and swear, or written signature at the end of each day, and attesting at the beginning of each day that they did not search the internet under penalty of perjury may be more effective. Here's some advice I've found while researching what appear to be the most effective ways for judges and attorneys to try to keep jurors off social media during trials. Repeat jury's instruction often. We've already talked about that, especially at the beginning of each day of trial. Explain to jurors the reasons behind internet restrictions. And a lot of people think this is critical, and I do too, and I'm gonna share with you some model jury instructions that I found about this. Provide examples of the types of social media use that would be improper. Alert jurors of the personal consequences they face, including fines or being held in contempt of court if they engage in improper communications. Have jurors sign a pledge, we just talked about that, to refrain from improper communications. Include a poster in the jury room that reminds jurors of social media instructions and prohibitions. This one seems punitive and the road to having an angry jury, but it's out there, so I'm going to include it. Confiscate phones at the beginning of each day of trial. Here's that excerpt from jury instructions that I found effective at communicating the why behind internet restrictions. In our daily lives, we may be used to looking for information online, and we may Google things as a matter of routine. Also, in a trial, it can be very tempting for jurors to do their own research to make sure they are making the correct decision. However, the moment you try to gather information about this case or the participants is the moment you contaminate the process and violate your oath as a juror. Looking for outside information is unfair because the parties do not have the opportunity to refute, explain, or correct what you discovered or relayed. The rise of social media, of course, also has given rise to attorneys using it to their advantage. I'm sure many of you, if not all of you, commonly check the internet daily to know what is out there regarding your case. You use Google Alerts, you use paid searches to key in by topic, case name, attorney names, witnesses, jurors, etc. You may monitor witness and or victim websites, check jury footprints based on voir dire answers, and you report improper jury activity as soon as possible. And that tends to come to the rise faster now via social media, but it's all still a work in progress. As recently as December 2013, in Maricopa County, Arizona Superior Court, a judge denied a motion by defense counsel to require jurors to reveal their Twitter handles so that accounts could be monitored during the trial. The judge ruled that there was no basis for such monitoring, absent a credible allegation that juror misconduct has occurred. There's little debate, however, about the value of social media during jury selection. Back in 2012, the New York City Bar said that litigators may use social media websites for prospective juror research as long as no communication occurs between the litigator and the prospective juror resulting from such research. In 2013, jurors being chosen for the trial of George Zimmerman and the death of Trayvon Martin were provided questionnaires that specifically asked whether the potential juror had used Facebook or received or posted information on the site about Martin's death. And in 2014, the American Bar Association, through Formal Opinion 466, made it official, approving the use of social media such as Facebook, Twitter, LinkedIn, and Instagram to aid attorneys in picking out jurors, unless lawyers are limited by law or court order. 466 also encourages judges to advise jurors that attorneys may be researching their social media sites. And I think that's also a critical point. It seems fair and reasonable that just as jurors learn why their social media use is being restricted during trial, the court should be transparent and explain why attorneys may be reviewing their social media accounts. It's also important to remember that for many people, even though social media can be out there for all to see, and even though they haven't taken the steps to secure their social media accounts, the idea of people they don't know prowling their accounts can be very confusing and off-putting. But the amount of information you can find out about a person on social media is staggering. There are limits, of course, as to how far attorneys can go vetting social media sites. 466 specifies that attorney requests to friend jurors on Facebook or to have another person friend them are improper under the prohibition of ex parte communications between attorneys and jurors. And as we mentioned, the New York City Bar went further, saying that should a juror receive a network-generated notification that an attorney has visited their website or social media channel, that too would constitute an improper communication and could violate the New York rules of professional conduct. As of now, most social media sites protect the privacy of the users, that is, the people doing the searching, over the privacy of the people with the social media accounts. So the owner of a Facebook page, of a Twitter account, of a profile may not know specifically who has visited their page or account. The two most important and obvious exceptions are Twitter and LinkedIn. If you choose to follow someone on Twitter, that person will be alerted that you're now following. But there are many ways around this one. You don't need to follow someone to see what they're tweeting. Simple search can get you that information. Additionally, There are companies that focus on cyber electronic discovery that offer a specialized public follow feature that can get you access to tweets without generating an automated alert to the Twitter account holder. LinkedIn, I believe, is more problematic. Unless you request otherwise, LinkedIn will show people when you visited their profile. And even if you request otherwise, LinkedIn may still show a user something along the lines of, an attorney at Acme Law Firm visited your profile. Therefore, in our opinion, to be safe, attorneys in New York should stay off of jurors' LinkedIn pages. One more important caveat, and then we're going to take another break.
Okay, good.
On most social media sites, the stories section, Twitter calls them fleets, F-L-E-E-T-S, will show the account owner who has viewed them. So Facebook stories, Twitter fleets, Instagram stories, and Snapchat will show who has viewed the content in those stories channels. Simply going on a person's account, though, will not generate such a notification. Now, you don't have to go nearly that deep or exactly be an internet forensics expert to find problems with prospective jurors on social media. We're going to talk about that in just a second. So, for fun, if you want to find problems with respect to jurors on social media, search hashtag jury duty on Twitter, Instagram, other social media sites. What you'll find can be quite instructive. You'll find things like interesting posts like this from Evil Penguin. Well, I have jury duty today, kind of excited to see what it's like. Guilty, I say. Or, also, I might have jury duty soon, and that is a horrible idea because I'm spiteful and will vote guilty because I hate people. We're going to spend just a few minutes talking about social media as a litigation communications tool, and then we're going to wrap up and take as much Q&A as you have or as time allows. 2003, James Haggerty wrote what's considered by many to be the Bible of litigation communications. He made one of the early arguments that social media had to be part of the litigation's communication strategy. It is not at all overstatement, he wrote, to say that the world in which most lawyers are practicing has changed immeasurably over the course of the past 2 decades. We have entered an era of 24-hour news, web blogging, and 500-channel cable boxes. In this new media-saturated environment, it is becoming increasingly clear that old approaches to media and public opinion just don't work. As lawyers, we need to adjust, just as surely as we adjusted to online research, computerized document management, and electronic filings of pleadings. Of course, when Haggerty wrote this, Facebook had just launched. Twitter was 2 more years away. And guess what? The approaches that were pioneering in 2004 in Haggerty's brave new world of 500-channel cable boxes now are old approaches. In a world where 24-hour news seems quaint, and most stories about cable TV involve people cutting it. So let's use the tried and true who, what, when, where, how approach to talk about best practices for today's use of social media and litigation communications. Let's change the order. If you're considering this, I think one of your first questions should be, where are the key audiences for this litigation issue getting their information? One of the tools of the social media trade is knowing which channel will work best for you and the information you want to impart. Is it newsy? Twitter's become, again, remember, the go-to place for breaking news. Are journalists an important audience? Again, Twitter. Would you like to have your communications shared widely? Use Facebook. I'll say again, according to Pew, as we noted earlier, 81% of all content shared in the US is shared on Facebook. What are people saying about your issue on social media? Is misinformation circulating? Correct it and link to corroborating independent information from your social media post. Don't allow factual errors about your cause or issue to live online forever. Who are the key social media influencers interested in your case or issue? Look for Facebook pages or other digital sites that may have been set up to address your issue. If people are talking about your case on Twitter, are they verified users? As I'm sure almost all of you now know, verified users have the check mark and the little kind of bluish cloud next to their names. You apply to Twitter for verification. By the way, Twitter shut that down for a while. They've returned it on. And why that's important is that Twitter users consider the verification check a check of authenticity. And people who have the verification check are more often to be retweeted, cited, and therefore they have more influence automatically. So you monitor those more closely because they do likely have more followers and more influential followers. How do you use social media effectively for litigation communications? You have to be responsive. Social media is built on two-way communication. You have to work fast. Social media also is built on speed. You have to remember your audience. You aren't necessarily responding to a specific social media user. You're responding to all the people who are reading that post and waiting to see what you have to say. And when is the best time to utilize the reach of social media to help your case? Well, let's look at a real world example. Consider what Mark O'Mara, the defense attorney for George Zimmerman, who, as we mentioned a few minutes ago, was on trial for murder in the death of Trayvon Martin, did. The book Social Media in the Courtroom, A New Era for Criminal Justice by Thaddeus A. Hofmeister described O'Mara's social media strategy. With social media, Zimmerman's defense team could circumvent traditional media outlets and reach the public directly. This direct connection to the public allowed them to, one, dispute misinformation about the case. Remember, we already talked about that. Two, discredit and eliminate fraudulent social media profiles of people claiming to be George Zimmerman. Three, reduce speculation about the case in George Zimmerman. Four, raise funds for George Zimmerman's defense, and they did that quite vigorously. Five, react to developments in the case in real time. And six, post relevant legal documents that they were able to post. It didn't all go smoothly. As Hofmeister notes, O'Mara had to shut down his George Zimmerman legal case Facebook page because the commenters got so nasty. But O'Mara himself said the use of social media in the case was critical. Here's what he said specifically. We contend that social media in this day and age cannot be ignored. It is now a critical part of presidential politics. It has been a part of revolutions in the Middle East, and it is going to be an unavoidable part of high-profile legal cases. Just as traditional media has been and continues to be, we feel it would be irresponsible to ignore the robust online conversation, and we feel equally as strong about establishing a professional, responsible, and ethical approach to new media. Hofmeister's book, by the way, could be considered a new Bible, at least for social media in the courtroom, I believe. He's an associate professor who researches juries at the University of Dayton School of Law in Ohio. He's emerged as one of the top voices on the issues around social media and the law. His book is filled with helpful advice and cogent observation. His blogs, Law and Social Media, and Law and Social Media and Juries are worth checking out. Not surprisingly, he's also a strong advocate of using social media. As illustrated throughout this book, Hofmeister wrote, social media is the proverbial game changer that has influenced every stage of the criminal justice process. In addition, and arguably most importantly, social media has shaped the outcomes of numerous cases. Defendants have been both acquitted and convicted based on how well the prosecution or defense employed social media. Thus, in order to stay relevant and be in compliance with the ethical rules, attorneys need to be able to both understand and use social media. One of Hofmeister's strongest arguments addresses that thorny problem of jurors and social media. He actually offers that the technology is new, but the issue of jurors and outside information is not. And he says, we've dealt with it more effectively than not for years. Courts need to acknowledge that some people just can't stop using social media, he argues. Jurors should be equal partners in the courtroom, tell them why they can't do things. No question, social media and social networking can impact the justice system. So could telephones and the public library 60 years ago. We didn't monitor whether jurors went to the library during jury trial, nor did we wiretap their phone conversations. We trusted jurors to do the right thing by imparting on them just how important a role they played in rendering justice in this country. The same will be the case for social media and social networking. So what are we left with here? Plenty of pros, I think, to the emergence of social media and the courtroom and journalism. It bridges the gap between no media coverage and opening up the courtroom to cameras. No immediate media coverage. Social media is actually a lot less obtrusive than cameras. It opens the court and the practice of law to a new audience that otherwise might pay no attention to the courts. And it has provided new effective tools to expose potential juror bias before trials and for litigation communications. You would probably agree there are cons. We've had a raft of mistrials, and that upsets the criminal justice system, and it's expensive. It costs a lot of money. From jurors ignoring judges and hitting the internet during trials. And that also causes an already sometimes slow justice system to slow down further. Testimony reported and widely circulated that may ultimately be stricken from the record can now go out live via Twitter or live blogging. And as we all know, once it's on social media, there are no takebacks. At a murder trial in Knoxville, video coverage was permitted, but under the judge's instructions, they were not to include graphic photos of victims used during testimony. Reporters tweeting during that trial, however, could describe those photos with no limits. I'm also going to offer that even this far into the social media era, and we're now years into this, and it's ubiquitous in our lives. Even now, there's a lot still unknown when it comes to the impact on trials and the criminal justice system. What's the effect, if any, on judges and lawyers being able to see reporters and the public's thoughts and analysis and the public weighing in as the proceeding is taking place? Perhaps it's nothing, but y'all are human. Who's a journalist? Some courts allow credentialed media to tweet from the courtroom, but not the general public. Who makes that determination? And this is an era when an individual blogger can have a larger following than the circulation of a mid-sized newspaper. So who decides who is a professional journalist and eligible to tweet from the courtroom? What's the impact on witnesses? We just spent a lot of time talking about the impact on jurors and the steps being taken to respond. But there's been precious little research into the impact, if any, on witnesses. In fact, I've had a hard time finding any. But imagine this scenario. Witness testifies. There's a break in the trial before cross-examination. During lunch, the witness reads social media coverage and public reaction to his or her testimony. Does that change or somehow affect the witness's future testimony? Now, I realize witnesses can be sequestered as well. But what steps are being taken to stop them from checking social media, whether sequestration has happened or not? Bottom line here, at least to my eye, there's been astonishingly little hard research as to the effect on trials of live coverage on Twitter and other social media, other than the obvious juror misconduct. And other than those high-profile cases that get flipped on appeal or declared mistrials, usually because of juror misconduct, there's very little research on the effect of the use of social media by and on jurors, witnesses, attorneys, judges. That, I would offer, is the next unexplored frontier. Thank you again very much for taking the time. I'm happy to answer questions. Let me just mention that there are parting gifts. I saw how few of you wanted Michelle to send additional emails. Nevertheless, what we're going to do is hit you with an email that includes these handouts. On the left is a Bruce Hennes production that's proved very popular with our clients and attorneys. It's a foldable, wallet-sized instruction manual with lots of practical tips about social media, about when the media calls, and other matters. On the right is a story that was done about iterative journalism, if you want to take a deeper dive, mostly driven by an interview with myself and Bruce. And what I'd like to do is share with you a copy of our twice monthly newsletter. which is, yeah, it's a marketing tool. And Bruce would kill me if I didn't do this part, but we don't use it to market. We use it to try to impart information. It's filled with practical tips, pragmatic advice, best practices. I write for it. My colleagues at Hennes write for it. And we scour the web looking for best practices like I talked about today with social media in the courts. We have about 8,500 subscribers, including thousands of attorneys. Don't want to fill your inbox with something you don't want, but I'd like to send you a sample, and it's very easy to subscribe. In fact, you can subscribe now simply by sending your email to hennes@crisiscommunications.com. And with that, questions?
Amy?
Coming on. There we go. All right. What about Google and Facebook censors?
So what we're seeing on Google and Facebook is now, in this era of fake news, the social media sites and the search sites are trying to respond. So I don't know that I would call them censors, because I don't think it lives up to the at least the legal definition as I understand it of censorship, but they are battling to try to stop the widespread use of misinformation. That can get political. You can be on various sides of that issue, but the social media sites particularly, faced with Congress now threatening to take away their greatest legal protections, are going to act. In part, what they're doing, Europe is ahead of us on this issue. And so in Europe, for example, the various countries, as well as the EU, have set up review boards. The review boards consist of trusted authorities on the subject, leading media members, and they evaluate information and then talk to the social media sites. A similar system is being set up in the US using Pointer, PolitiFact, and some others. So what do I think of it? I think we need to do everything we can to try to stop the spread of misinformation without fettering the free flow of information. And that's a tough balancing act, I realize. But I don't think we can sit back in this era when fake news is all the rage and do nothing.
Have you had experience or circumstance where a savvy judge issued a gag order to plaintiff's counsel, but your organization had been retained for real-time tweeting and management of social media?
I'm thinking. We have worked plenty on litigation communications. And I, in the past, a couple of times have served as an expert witness on social media and media matters. I don't recall a situation where one side like that, where the plaintiffs were gagged, if I understand the question correctly, and we were still able to go forward.
Someone wants you to repeat the site for the 2020 updated jury instruction on social media.
Oh, that's that is via, hang on a minute, I'm gonna have to go back. That is via the ABA, I believe. So that came out in October of 2020. They updated the recommendations. Hang on a minute, I'm gonna get to it in just a sec here.
I pasted the course materials link in again for everybody in the chat. So you all have these materials too. So if you miss something, you can go back and get them in the materials.
Right. So let's take the next question while I'm scrolling here.
Okay. Can social media posts be used in matrimonial custody proceedings? Ex-spouse's new girlfriend posts negative comments about kids or sexually inappropriate comments, etc.
So my understanding is that social media is increasingly being used as evidence. We didn't really explore that a whole lot. It obviously, it has to meet all the other parameters for admissible evidence. But yes, it can. And I was involved in one situation where the divorce ended up being called off, so it didn't go forward. But indeed, we were collecting social media evidence and intended to use it during the divorce, particularly for in the case of deciding who had who had the children. And it is the American Bar Association, which in October of 2020 updated Formal Opinion 466 with some other information.
How can you certify the accuracy of a social media download?
Okay, that's a good question. So, a couple of things. When you're looking at that social media download, this speaks to the whole idea of how do you find fake news? You try to get to the original source. What is the original source? And are they in a position to know? You know, is it even if it is a reputable media outlet, one thing to check is someone else saying it? Is someone else reporting it? Now and then in my 33 years of newspapering, someone broke a huge story and they were absolutely alone on it. A couple of times we were fortunate enough for that to be my newspaper, but it's rare. And one thing to immediately check is, especially if it's the media, if there's somebody reporting on something that sounds unbelievable or outlandish, see if someone else is reporting on it. That's one tell. Another one is what is the originating website's name? And does it ring true? They're defunct now, but for a while, there are a couple of tells on that. .co is often used. So I think it was Bloomberg. There was a Bloomberg.com.co. So suddenly in the URL, there's an additional little weird thing at the end. That's a marker for something that's probably not legitimate. And then I would also say, you try to, if photos are involved, there's a very easy way to use Google photo search that will show you when the photo was originally taken and what the circumstances are of it, because fake use of photos is one of the most frequent uses of fake news.
Matthew clarified that last question and asked, how can you be sure the download is an accurate duplicate of what is on the social media page versus what's been altered?
Yeah, that's a great question. You need to try to get to, obviously, and this is you need to try to get to that original social media post and check it out versus the download.
What prior restraints applied to newspapers in the old days before social media to limit the fake news being published? And what did editors do to address this?
So there really weren't prior restraint, right? The yellow journalism era I referred to, the late 1890s, early 1900s, was infamous. I mean, there were giants from the business. William Randolph Hearst, Joseph Pulitzer, for whom the Pulitzer Prize is named, who indulged in fake news. It's partly apocryphal, but the famous example is that the Hearst and Pulitzer newspapers, which were competing in a death struggle for readers because there were so many newspapers at the time. See if this sounds familiar. Price of printing presses went down, price of paper cratered, and suddenly everybody had a newspaper and there was this intense competition and people started to make stuff up to get readers. That sounded all familiar to anybody? So Hearst and Pulitzer were locked up in this, and they did not cause the Spanish-American War. Historians have since said that's fake news. That's an exaggeration. But they both reported stories that were not true about the sinking of the Maine, which was the triggering event. And there's little question from historians that reporting helped steel American resolve for entering the war. Now, that said, what are the restraints? The restraints, again, a lot of it speaks to readers. The yellow journalism era ended because readers decided this sensational fake stuff was getting over the top and I don't want to read it anymore. The New York Times nearly went out of business in the early 1900s, and Adolf Ox Sulzberger, the family patriarch, owners or still descendants still own the paper. He decided that he was not going to indulge in this. He didn't do comics. He didn't do made up stories. He didn't do contests. And over time, in a relatively short period of time, readers were attracted to legitimate news over fake news. And the restraint, so the best restraint to keep media outlets legitimate and to keep them reporting real news is to read the real news, and especially these days, to pay for the real news. If there are legitimate media outlets that you believe in and you embrace Americans vote with their wallets, ultimately. Pay for it. And don't pay for the stuff that's sensational and outlandish.
What threats from the government do journalists face, and how can lawyers help protect journalists?
Well, we saw some of those threats come up early in the Trump administration when they started talking about things like changing the libel laws, changing the famous New York Times versus Sullivan, allowing media outlets to be sued for mistakes. Media outlets have to live up to the great responsibility they've been handed. It's really the only business, independent, for-profit business, that has Bill of Rights protections. So journalists have to live up to that. But I would argue, if I can climb on my soapbox for 10 seconds, that those Bill of Rights protections are a bulwark of our democracy. And while the journalists have to live up to their end, we also should live up to ours and support that, and support the legitimacy of journalism, and the legitimate journalism matters.
Are you aware of any civil personal injury cases that have been affected by social media interplay?
Yes, and if you want to email me separately, I can send you some examples of that, but that is increasingly coming into play. And that's where we're seeing social media as evidence have kind of a bigger impact. It's certainly being used as evidence in criminal too, but we're seeing it increasingly used as evidence in civil, to challenge the veracity of witnesses, to make the case for the plaintiff or defendant. And I do not have them at my fingertips, but in researching for this presentation, I ran across several that were cited.
Shouldn't journalists be held to the same standards as attorneys to investigate and find the truth?
Journalists should be held to high standards to investigate and find the truth, because the damage that can be done by illegitimate, false, or misleading stories is great. That said, journalists are not attorneys, nor are they law enforcement. And I would argue that one of the fundamentals of a free press is to avoid blurring those roles.
All right, here's the last one. Chris says, I had a case where a photojournalist was arrested for taking pictures of the mayor on a public sidewalk in front of a public hospital. Do you believe that in today's climate, journalists are not being respected by government authorities?
I think there's no question about it. Look, it's not really today's environment, though. I mean, this has been the adversarial relationship has existed forever. I was hammering away at the yellow journalism era. There was some really good yellow journalism done during what's now decried as the yellow journalism era, including the Pulitzer and Hearst newspapers writing a series of stories that drove corrupt politicians like Boss Tweed out of office in New York. So that adversarial relationship has existed really forever. Jefferson both loved and decried the press at the same time. The difference now is, as is the difference with so many things, social media puts it on steroids. It's out there for everyone to see. And journalists, when I was doing journalism before the internet era, I heard from readers once a week, once a month, and then digital communications, email and social media hit, and I heard from a wave of them every day. And that was to the good and bad. And I would say more largely to the good, because they were holding our feet to the fire. And they were demanding that we live up to our standards. And I think that's a good thing. So I think the adversarial relationship is actually right. I think that we have seen the decline, as you all know, in trust in all of our institutions, including journalism, and rebuilding that trust is going to be hard, but it's up to the media outlets and the journalists to do it. I think that was Amy. I'm guessing that was our last question. That's all we have time for.
2 more popped up.
Okay.
How you investigate a prospective jury panel without them knowing you are actually looking them up?
Well, that's an interesting question, right? Because one of the recommendations for best practices for jury instructions actually is to tell the jury that they're going to their social media sites are going to be investigated. And I tend to side toward that transparent end. I mean, and this was not my idea. It's on a bunch of different sources. It's cited this one as a good best practice because, again, if jurors are being told all the reasons they can't use social media, then it just seems fair and transparent to tell them that their social media channels are going to be checked out. And it actually puts them on notice and may have the effect of keeping them off of them. So I guess my answer is I think they should know.
I'm not sure if we touched on this one before. Can you use evidentiary material from social media / the internet at trial? I would think it would be objectionable as hearsay unless there is some sort of exception to the hearsay rule. I can't.
Yeah, we didn't delve into evidence with this. There's a whole raft of information out there about it. I'd encourage you to look for it. If you just look for social media and evidence, it'll turn it up. Thaddeus Hoffmeister's book, which I'm obviously a big fan of, has a chapter on evidence and social media. It has to meet all the evidentiary rules, but we are seeing it increasingly admitted to court and being used.
Okay. That's it.
All right. Well, let me just say before we wrap up that I so appreciate the time, so appreciate your attention. Holiday week, and this opportunity was a tremendous one for Hennes Communications. We will be in touch with those handouts. Check out the newsletter if you would like to subscribe. We'd love to have you. If not, that's up to you. And my last thing is happy holidays, Merry Christmas. Use social media wisely.
Bruce, did you have anything you wanted to say as we're wrapping up?
I just want to second what Tom said, and at the risk of being mercenary, we have a great newsletter, and we promise you no advertising, no spam. We will never give your name away. We've constructed the newsletter so that it really is best practice link. You're not going to read anything about us until you get way to the bottom because you don't really care about us. You only want to know if you're going to give us 30 seconds, 60 seconds, 90 seconds to glance at our newsletter. It's got to be about you, and it's got to be about your clients. So give us a shot. Ask for a subscription. You can always cancel it very easily, or we'll just send you one issue. So I also want to say happy holidays to everybody. Michelle and Amy, thank you again for the opportunity. We would love to come back. I think Tom's got another seminar or two under his belt that he'd love to give to your attorneys.
Awesome. Excellent. Not till January. I need a break. So thank you all so much. If anybody has logistical issues, you're not sure you got credit, you screwed up the polls, you forgot what time it ended, you don't know what day it is anymore, I'm with you. Shoot me an email, info@trialacademy.org. Next to my head is the email address. And we will help you, or at least we will try. Hopefully we'll see you all back on January 6th. More emails will be coming from us with all of the upcoming January calendar. But if you just can't wait, feel free to go to our website and sign up. There are at least 9 programs already open for registration. Happy, merry. May 2021 be way better. See ya. Thanks, everyone.